If JoJo Siwa wrote the songs, then why can't she perform them publicly? It has something to do with copyrights and probably contracts. Coming up on Legalbytes. Hey everyone, welcome to Legalbytes. I'm Alita, I'm a lawyer, and on this channel we explain the law one bite at a time. And we are also more than halfway to our first 10,000 subscribers. So as you continue watching this video, if you are enjoying this content, be sure to subscribe and hit the notification bell so you can follow along on this journey and see more videos just like this. All right, let's get into it. So for starters, who is JoJo Siwa? JoJo Siwa is a children's entertainer who's been working with Nickelodeon since 2016 and is also widely known as an influencer in the same market. On Twitter, she has a little over 616,000 followers. On Instagram, she has just under 11 million followers. And on YouTube, she has 12.3 million subscribers. She's known for wearing really large bows and a lot of color. As part of her upcoming projects, she's starring in the J.Team, a movie musical produced by Nickelodeon. The J.Team started streaming on Paramount Plus on September 3rd. She also has a music tour lined up, which is supposed to kick off in January 2022. The controversy here stems from a handful of songs that JoJo Siwa purportedly wrote herself, which appear in the movie. Apparently, JoJo wants to add them to the song list for her tour, but Nickelodeon is not allowing it. So she took to Twitter to express her anger and frustration. Here's what she said. On September 15th, 2021, she said, "I go on tour in January. My movie musical was just released with 6 new original songs. Nickelodeon told me today that I'm not allowed to perform/add any of my songs from the film into my show. These are my songs, my voice, my writing. Does this seem fair?" And then she went further and she said, "There is no reason that this music should not be included. Working for a company as a real human being treated as only a brand is fun until it's not. I want my concert to be the best it can possibly be, and I want to perform the songs that you have been waiting to hear for 2 years. Having the music from my movie in my show is important to me. I wish it was important to Nickelodeon. Remember, I'm a human, not just a brand." So a lot of people are asking, why can't JoJo Siwa sing these songs, especially considering the fact that she says that she wrote them and she sings in them and those are her songs? Well, to begin, I do have to say that there is a little bit of suspicion involved in this analysis, and that's because I haven't seen any form of a contract between JoJo Siwa and Nickelodeon. However, given the value of these songs to both parties and the relative sophistication of Nickelodeon in particular, and probably JoJo Siwa at this point as well, I would imagine that there's some form of a contract in written form between the two parties. Now, at the same time, what we're really talking about here is a creative work. Music, songs, movies, TV shows, those all fall under the area of copyright law. And in the United States, copyright law is governed by the Copyright Act. So because new music is covered by a copyright, this means that the question as to how the music can be shared or reproduced or performed publicly is determined by the copyright owner. Usually when the owner of a copyright does allow performance of a work of art that is still under a valid copyright, there is some form of a license involved where the copyright owner is paid a certain fee or a certain portion of the proceeds as a result of the performance. So in any case, we have to figure out who owns the copyright. Now, normally under copyright law, the general default rule is that whoever creates the work is the first copyright owner. However, there are ways in which that can change, and there are certain exceptions to that rule as well. For example, an artist is always able to contract away their ownership of any of their intellectual property, including copyrights. And second, there are actually a handful of exceptions to that default rule carved out explicitly under the Copyright Act. Specifically, 17 U.S. Code Section 201B talks about works made for hire. Basically, long story short, this section says that an employee that's creating a work in the course and scope of his or her employment for that employer it basically does not own the copyright for the work that they're creating. The copyright is actually owned by the employer. And even where the creator of the work is technically not even an employee of the company, but they've been hired specially to create a work under certain circumstances, including works of art created for use as part of a motion picture, then the result is the same. The copyright is owned by whoever it was that hired the creator, not the creator themselves. So applying all of that to this situation, again, like I said before, I haven't seen any kind of a contract, and I'm assuming that one actually exists. But if I were to speculate further, I would say that there probably is not only a contract between the two of them, but probably a contract that also has terms that are specific about who exactly owns the copyright to the music that's created by JoJo Siwa for the purposes of that movie. In other words, I would expect to see language in a contract between the two of them stating something along the lines of Nickelodeon agrees to pay JoJo Siwa X amount of money for JoJo Siwa to create a certain number of songs for the movie musical The J-Team. And then I would expect to see language saying something along the lines of JoJo Siwa agrees that the music that she's creating for the purposes of the J-Team are songs for which she will not own the copyright, that those are songs that the copyright will be owned by Nickelodeon and only by Nickelodeon. In that case, even though JoJo Siwa wrote the songs, she technically would not be the copyright owner. The copyright owner would be Nickelodeon, and therefore Nickelodeon would be the one who would have the exclusive authority to determine whether or not those songs could be performed publicly. Now, that leads us to another question. Is that fair? Now, as it relates to this employment exception to the rule that the creator is the owner of the copyright, there are a number of reasons why those exceptions exist. And part of that has been just a result of litigation over the years. One advantage to having an exception like this that's written into the Copyright Act is it creates a sense of clarity. This is especially true in cases that require a lot of collaboration. Think TV shows where you have a whole team of writers, or movies where you have not just a team of writers, but you also have set design people, you have people that are working on soundtracks, you have people that are working on lighting, you have people that are working on sound. All of these people are working together collaboratively, and they are working creatively together to create one project. Now imagine if each of these individuals on a particular set decide that they want to sue for a partial ownership in the copyright. That creates a lot of chaos, and it ultimately hurts the bottom line of the industry. So for better or for worse, this is just kind of how this area of law has sort of shaped up over the years. Now, as I mentioned earlier, a copyright owner also is free to contract away their rights to a copyright. And in this case, I'm totally yet again speculating, but my guess is that there probably was this negotiation that happened as to the payment for the songs and the rights to the songs that probably happened before they were even created. And so my guess is that these songs probably were created for the purposes of the movie. Now, when it comes to determining whether or not a contract is fair, usually courts are going to be focusing on the time at which the two parties were negotiating for the contract. For example, what was the relative power dynamic between the two parties? JoJo Siwa is obviously a very big time influencer and is probably amassing quite a large amount of wealth through that influence. On the other hand, Nickelodeon is a very large company and has been around for a very long time. And again, because I haven't seen the contract, I don't know exactly when it would have been entered into. So whether or not that contract was entered into before JoJo Siwa amassed her massive influence online or afterwards could be something that would be relevant. However, even aside from that, probably a more important factor would be whether or not the two sides had a meaningful opportunity to actually negotiate these things. Even if in this case Nickelodeon was by far the more powerful party, it wouldn't necessarily make a difference if they weren't using that as an unfair advantage. And going further on that question, the court would also look to things like whether or not JoJo Siwa had her own representation, meaning did she have her own lawyer or team of lawyers negotiating on her behalf? And were those lawyers competent in what it was that they were doing? For example, were these lawyers that have been negotiating these kinds of contracts for a long time, or were they very inexperienced attorneys? Let's say attorneys that had just passed the bar exam and just graduated from law school, and this was their first contract that they ever negotiated, and they had no oversight from any other more experienced attorneys with them. Those kinds of factors could play a role. But generally speaking, unless there's some sort of evidence that is available that would show that the way in which the contract was negotiated or made was incredibly unfair to one party, generally speaking, a court would look at a particular contract and say, you get the terms that you negotiated for. If you had an opportunity to negotiate for them and you actually took that opportunity, then you get what you got. An example of this can be seen in the recent case involving another big influencer, Haley Page. Haley Page is a wedding dress designer and influencer who is currently in the midst of litigation with her former employer. Now, back when she was working with her former employer, she had a contract with them. And that contract had some terms about her intellectual property. Specifically, they said that she was turning over the rights to use her own name, first and last, over to the company, which basically meant that when they parted ways, she was no longer able to use her own name on social media. This means anything from Instagram to Twitter to YouTube. All of those things are technically still owned by her former employer. And when she tried to contest it, I think on terms of unconscionability, the court actually said, no, you can contract to give away even your own name. And although the Haley Page incident has to do with trademarks, whereas this particular case with JoJo Siwa would have to do with copyrights, they still fall under the wider umbrella of intellectual property. And all of that is to say that obviously none of this is legal advice, but when signing a contract that has anything to do with any form of creativity, that is definitely something to look out for before any signatures are made. But those are just some of my thoughts. What do you think about this case? Do you think that it's unfair for JoJo Siwa to not be able to sing songs that she wrote on her own tour? Or do you think Nickelodeon might have some justification here? Let us know in the comments below. Otherwise, I hope you found this interesting or at least informative. And if you did, I'd love it if you'd hit the like button. It does help us with the YouTube algorithm gods. And if you enjoyed this content and you want to see more stuff like this, be sure to hit the subscribe button and the notification bell. That way you can find out when the next video is uploaded. See you in the next video.